morning. I'm Carrie Jacobson with Jacobson Family Law, where we keep the drama out of your divorce. Welcome to Finance Friday. Today we're going to be talking about modifying an existing child support order and how you can go about doing that. So first, the place to start is to determine whether or not it's appropriate to modify your existing child support order. And so that in order to do that, we need to know, has there been a significant change in circumstances since the order was issued? Most notably, what we see is the changes that occur in order to modify that child support obligation are a significant increase or decrease in one or both of the parents' incomes. It could be a significant increase or decrease in the child or children's expenses. It could also be a significant change to the custodial access schedule that may impact the child support obligation. And so for any of those reasons, it might be appropriate to modify your existing child support obligation. So then the next scenario or question is, how do you go about doing that? And so there are a couple of different ways to go about making that modification or change to a child support obligation. The first is doing it through informal negotiations. And that can either be by you and your co-parent participating in mediation with a neutral third party who would facilitate the conversation between the two of you. And in many scenarios, you would do an informal exchange of income documentation or other supporting documentation that may be necessary when calculating child support. In my mediation practice, many times parents are simply exchanging that documentation by sharing their screen in a virtual Zoom meeting so that everybody can see exactly what the document looks like. It may be that you need to share copies of that documentation so each person has an opportunity to, review it in more detail. Once parties have reached an agreement in mediation, then what we would do in that scenario is prepare an agreement that says what the new child support obligation is going to be when it takes effect, that can then be filed with the court. Either you can do that, you can have your attorney file it, or in some circumstances, we can file it on your behalf. Sometimes it's not appropriate or parties simply don't want to engage in direct communications with one another through mediation. And so you may consider hiring an attorney to negotiate the terms of that child support modification on your own behalf. And in that scenario, you would work with your attorney, provide them with all of the necessary documentation. They could run the child support guidelines to see the different scenarios, and then make a proposal to your co-parent or their counsel. And in that scenario, oftentimes the attorneys are negotiating with one another to determine what the final child support obligation is going to be and getting their respective clients' approval on what that looks like. If you are unable to reach an agreement on what the child support obligation is going to be, or if simply your co-parent won't engage in those conversations, then you may have to file a petition to modify your child support in court. And in that scenario, you're going to have to file a petition to modify child support. You will have to have the other parent served. They will have an opportunity to file a response. And then you have a chance to do discovery. And that's an exchange or request for maybe questions, interrogatories. It could be a request for production of documents. You could issue subpoenas to different entities, whether it's an employer, a bank account, or other financial institution, or even the other individual themselves. From that, you're going to have a documentation to determine whether or not child support obligations should be modified. And you can also try to negotiate in that scenario. But ultimately, if an agreement can't be reached, then you will have to present your case and your request to a judge in a modification of child support hearing. You would have to provide all of the reasons why and documentation to support your request, and then the other side would have an opportunity to rebut that or say why they do not necessarily agree. And ultimately, it will be up to a judge to determine whether or not the child support will be modified. So that obviously can take some time. Cases do not necessarily go quickly. I would say generally here in Maryland, you're looking at a minimum 3 to 6 months probably for a modification of child support hearing to be addressed by a court. And so then you simply wait until that's decided. There are scenarios where you can ask for the Office of Child Support Enforcement, if your case is with them, to do a review. And there are scenarios where they can represent you and ask for a modification as well. So that is another option that may be available to you. If you have questions on how to calculate child support, whether or not your particular case is ready for a modification, you can always go to our website, which is jacobsonfamilylaw.com. You can also check out our e-course on child support in Maryland, which is a comprehensive guide to learn more about child support here in Maryland. And if you have any other questions, feel free to reach out.